So tonight we had to start at 5 because Mr. Knud had such a busy day, and with his pure dedication for our mentoring Mondays, he says he's sitting in a parking lot in his car while he's going to present tonight. So that's some serious dedication, Mr. Knud. I appreciate it. He wanted to do his own bio, but I'm not sure he'll highlight everything in his bio, but he's got an associate's in wildlife technology. He's got a bachelor's in engineering, civil engineering. He's got a master's in civil engineering with surveying and mapping emphasis, Ph.D. civil engineering from Penn State, and a doctorate of jurisprudence. I had to look that word up and I had to get Google to pronounce it. I will admit that. And from West Virginia University. So I don't know if I stole some of your thunder, Knud, but we definitely appreciate you jumping on and supporting Mentoring Mondays. And thank you for your service, which I'm sure you'll talk about in your bio. But
all right. Well, yeah, just add, I grew up on a dairy farm around Gettysburg, Pennsylvania. Went in the Marines. And, Marines were kind enough not to send me to Vietnam, sent me to surveying school, and then 4 years surveying, got out, worked for a small surveying firm, just me and the boss pretty much, and decided to go to college. But I went to college after I got licensed as a surveyor, and as you can tell from Trent's intro, I stayed in college for quite a while, but I am a licensed surveyor in several states, a professional engineer, and attorney at law. I've taught at the University of Maine for over 30 years before retiring, and during those 30 years, I did consulting work. In fact, I worked several years for a forestry company that just focused in on boundary surveys. My consulting work is varied, as you can imagine, being both a lawyer and a surveyor. Almost all my surveying involved disputes. I've litigated cases. I've appealed cases all the way up to the Maine Supreme Court. I've been an arbitrator, a master. I've been an expert witness numerous times. So I've dealt with boundaries from surveying to litigating to, getting the rules of construction established through appeals to the Supreme Court. And so I'm bringing that to you. I think I mentioned I'm licensed as a surveyor in several states. So I've dealt with boundaries in from the Western public lands, licensed in Wisconsin for several years, West Virginia, Pennsylvania, Maine, Florida. So, have that, the various states from colonial to public land survey system states. All right, let's talk about adverse possession and the surveyor's role. By the way, if you didn't get these handouts, just copy my email down and send me an email and I'll send them right to you. No problem there. So let me just pause a little bit. If you haven't copied my email, to go ahead and copy that down, and I'll send you the handouts. Plus, if you ever have any general questions, I'll be more than happy to. I'm only licensed as an attorney in Maine. I was in Pennsylvania for many decades, but at my age, you realize you're not going to get back in certain states. So I've retired my license in several states. So I mentioned that because if you have a very specific question in a state that I'm not licensed in, I won't be able to answer that particular question. Just because it would be practicing without a license. So what is adverse possession? Adverse possession is a method whereby a individual or even the public company can acquire fee simple title through possession that's adverse to the record owner. So what's required? It's not just a matter of, well, I've occupied somebody's land. I should now have title to it. You have to meet very specific elements. And these elements are generally the same in all states, but some states do have some differences. The biggest one being, as we'll talk about, the statutory time period. But what are these elements? Now, before I go through the elements, I want to make it very clear that you, as a surveyor, are not required, and in fact should not, and I'm going to emphasize that several times, should not be opining whether your client has gained or lost land through adverse possession. I, as an attorney, would never, ever tell a client that they've gained or lost title through adverse possession. I've seen too many times where I might think everything is in favor of adverse possession, and when it goes to court, the judge thinks otherwise. Let me just say this, just to emphasize what it's like when you're litigating a case. There's two rules that trump everything in court, everything. They trump monuments, control measurements. They trump every rule of construction that you know at the trial court. These two rules are supreme. One rule is it's better to know the judge than the law. And I got lots of stories about that. And the second rule that I always tell my clients is you get as much justice as you can afford. And if you can't afford much justice, you don't generally win. I don't care how the facts are in your favor. All right. So I know that's a very cynical view, but like I say, I've been an attorney for 30 years practicing law, and I've seen too many examples of these two rules trumping other rules. And some of you that might be listening to me that are surveyors and been in court as an expert witness, you might have some individual examples in your mind about that. So never, ever tell a client that they've lost or gained title by adverse possession. And there are some legal considerations that are not under these two rules that surveyors don't often realize are present or how they affect the law in that state. All right, so let's go back to these elements that you want to be looking for. But again, it's not your job to say, oh, this is it here, this is not. It is your job, though, to counsel your client that title may, not did, will, or has, but may be lost or gained by adverse possession. The first element is actual possession. All right, so what's actual possession? Actual possession requires that the person that's going to claim title by adverse possession actually take possession of the property versus constructive possession. Constructive possession is when their deed covers the area. So in other words, think of an overlapping title where two deeds, if you were to plot them out, actually overlap each other. One owner, no doubt, has actual title. The other one has paper title, but is said to have constructive possession of the property that's within the bounds of their deed. So actual possession doesn't go towards adverse possession, but actual possession is required. Now, there's a little caveat to that I'm going to cover in a little bit where constructive possession does come in. But let me get through these elements. So the first element is it's got to be actual possession. The second element, it has to be open and notorious possession. Think of the septic field that's over on the neighbor's property. So your client, you go out there, you survey, and you notice, or you determine that part of their septic field is over on the neighbor's property. The only thing is you don't notice it. There's no mound. It's just the only way you've picked it up is there's a little leakage that your nose detects. All right. But that's the only thing. I mean, it's not noticeable. That possession, even though it's actual possession, is not open and notorious possession. The possession has to be of such a nature that the record owner is put on notice of this possessory claim. Now, I've often been asked, well, what if the owner never went there? I mean, let's say it's a section of land, and there's one corner of that section that the owner just never visits, never goes out there, never sees that possession of part of his or her land. Doesn't matter, because if a reasonable person should have noticed the possession, then the law presumes that the owner should have known the possession. So you can't have the owner, covering his eyes with his hand and putting on, muffs to muffle the sound and saying, I saw nothing. I never saw nothing. Therefore, there can't be open and notorious. No, it's whether a reasonable person, if they walked out there, would have noticed the adverse possession, not whether the owner actually ever did. So that's open and notorious, the second element. The third element is it has to be exclusive possession. The possessor has to treat it as if it were their own property. It can't be like a community property. It can't be like maybe if you go back to your high school days, for some of us, that's, several decades ago, and maybe some listening to me, it's only a couple years ago, but maybe there's this spot where everybody went and everybody would hang out there that, the cops didn't know about it. And more importantly, your parents didn't know about it. And you did all kinds of things that you didn't want the cops and the parents to know about. Right. And you could say, well, we were there, we possessed it, it wasn't our property, it was open and notorious, and it was actual possession because, we built a little gazebo and so on, but it's not exclusive possession, right? It's not just you treating it like it was your own land. Not that it has to be just one person, but it has to be of a form that a record owner would have treated their property. That's exclusive. It has to be hostile possession. All right, that's the fourth element required. The hostile possession must be of such a nature that it's clear that the possessor would defend their claim against the record owner if the record owner were ever to dispute their claim. The possessor doesn't have to actually dispute the claim if the record owner never tried to exert their record claim. It's just that it's such a nature that the hostile owner would have. They fenced it, they put their building on it, they made it known that it's their property. They may have kicked people off of that property, not necessarily the record owner, but they may have kicked off the neighborhood kids or somebody walking through, or a trespass or a hunter. They've exerted their authority as if they owned the property. that's hostile possession. And you don't have to show there was a war. You don't have to show there was, fists thrown or shots were fired. It's just typical acts of what an owner would do in order to protect the sanctity of their own property. The next element is there has to be a claim of title. All right. Generally, the possessor has to show some good faith claim. The person that goes out and, let's say, visits a national forest, the national forest would be a problem anyway, but goes out and visits and says, oh, this is so beautiful, I would love to have a place here. And then they look up adverse possession and say, well, I'll just go ahead and it's so remote, I'll build a little cabin here and wait for the statute of limitations. And, I'll just claim that title. They don't have a good claim. Generally, what the courts want to see is the possessor presume they owned it based on their deed or some, even if the deed was just a color of deed or a paper title, as it's sometimes called. The courts generally require that there be some good faith effort of the possessor to meet this element. Next, it has to be continuous. The possession has to be continuous throughout the statutory period that we'll discuss in a couple of minutes. This possession can't be interrupted by the record owner. If the record owner comes in and let's say moves the building off of their property or moves the fence or tears down the fence during this statutory period, then if the possessor builds the building or erects the fence again, the possession starts all over again, day one of the statutory period. Now, there's a little exception to that if the record owner comes out and rips out the fence and they immediately starts putting it in. There's a little bit of leeway there, but if there's any delay at all, it starts day one again. So it has to be continuous possession for the statutory period of time. Now, just jump. This other element is the statutory period of time, and that does change by state. For example, Pennsylvania was 21 years, Maine is 20 years, Florida is 7 years, West Virginia is 10 years. So what you want to do is take a look at your state statutes and see what the statute of limitation is for the possession of real property. And there's statute of limitations, by the way, on many actions. For example, if you go and steal somebody's valuables, if you manage to keep them without being caught for so many years for the statutory period of time, they can't prosecute you. You're off the hook. If a surveyor does some negligent act that ordinarily would subject the surveyor to payment of damages to the injured party, and the surveyor is not sued within the statutory period of time, the surveyor can basically say, yep, I pitched the pin up in the air and where it landed, that's where I pounded it in. And yes, I know that's negligent, but it's been 30 years and so what? And it truly is. So what? There's nothing you can do about it. The statute of limitations has passed. There was even in many states a statute of limitation on murder. I don't know if some of you are old enough, but there was a statute of limitation on Germany where the Nazis that sent Jews to the death camp were going to get off the hook after this time. I think it was 50 years. And Germany then revised their statute of limitations, but I'm sure there's a lot of war criminals that were just hoping they can get by that, and then they can go out and say, "Yeah, I was, a death camp guard, and We sent, 10,000 Jews to the gas chamber. So what? You can't do anything now, the statute of limitations. So there, there's a statute of limitations for everything. Most of us might be interested. I'm sure nobody listening, but most of us might be interested in a statute of limitations for the IRS for filling out the our taxes wrong and not and maybe getting a little extra money than we shouldn't ordinarily have had, or failing to claim some income. The statute of limitations for IRS taxes is 3 years and 5 years. 3 years if it's negligent, 5 years if it's intentional. If you actually intended to defraud the Internal Revenue Service of taxes, there's a statute of limitation for that. So check your state statutes that the state you're in, just, find out what that statute is. And again, as a surveyor or even as an attorney, it's not up to you to decide that all these elements have been met and therefore title has been created in the possessor or lost against the record owner. But you can certainly counsel your client about possession of maybe the client possessing the neighbor's land or the neighbor possessing some of the client's land. Now, a couple of terms here we want to talk about when we talk about the statute of limitations. The terms are privity and tacking. Let's assume, for the sake of this discussion, that 20 years is required for adverse possession. And the current owner or possessor, let's put it that way, has only possessed the land for 10 years, but their grantor possessed it for 15. So the current owner, if they could claim their grantor's possession of 15 with their possession of 10, that would give 25 years of adverse possession, meeting the statute of limitations of 20 years. Well, the law allows you to do that under what's called tacking. You can tack a previous owner's possession to the current possessor's time in order to meet the statutory period. But in order to be able to tack, there must be privity. So what's privity? Generally, you get privity through one of two ways. One way is that the possession is the possession, not the title. I want to make that clear. The possession of the previous possessor is transferred to the current possessor by deed. All right. I know some of you are saying, well, wait a minute. If the previous possessor only had 15 years, they never had title because you told us the statute of limitations is 20 years. So they never had title. Doesn't matter. In my 30 years of practice as an attorney, I've come to realize that a lot of people give deeds for property that they have no title to. And I'll be frank with you. I've practiced in half a dozen states, and I've yet to see a single registrar of deeds ever question whether the person giving the deed had title to the property that's being recorded. I have yet to hear of a registrar ever saying, when they get a deed and saying, wait a minute, are you sure you actually own this property before I record this deed? Never. I swear I could write a deed from my wife to me conveying the University of Maine to me and go down to the Penobscot Registry of Deeds and record that deed. And the registrar, Susan Boulay, wouldn't blink an eye. For one thing, I doubt she'd even read the deed. But even if she did, she would record it. However, what she will do, and every other registrar that ever is going to make sure you pay the property transfer taxes. And generally the transfer taxes are based on the value of the property. And I'll bet you the registrar down there would figure that the University of Maine is worth several $1 million, and I'd have a heck of a bill for the transfer taxes. And I can't go and tell Susan, I say, Susan, I really don't own this, so can I kind of get a pass on the transfer taxes? It ain't going to happen. All right. So this privity that we're talking about, sometimes when I litigate an adverse possession claim, I have to go back to my client's grantor and get a deed, quitclaim deed. I guess tonight we're not going to talk about quitclaim deeds, but I don't have enough time, or the various deeds. But I would get a quitclaim deed from my client's grantor, conveying them this possession area. Now, I may request that a surveyor go out and survey this possession area. And again, I've had some surveyors question me over the years saying, Knud, you know, I've checked the records. Your client doesn't own that property. You know, I've looked at the descriptions. What you've asked me to survey and write a description for, they don't own. And I said, I know. Just go ahead and write it up. Well, I don't feel right. I mean, I'm describing somebody else's. I said, it's all right, but put a big note on the plan. I don't care. I need a description. I'm not going to file it. I'm not going to record it. I just want to have the, you know, bearings and distances so I can write that in to a quitclaim deed, have the grantor sign it, conveying that over to my client so they can tack. Now, I don't want to get too deep into litigating adverse possession, but I've also defeated adverse possession claims because I've realized that my client, who has the neighbors claiming adverse possession, falls short of the statutory period of time. And before they can get a quitclaim deed from the grantor, I get a quitclaim deed from the neighbor's grantor so that the neighbor can't, and now they'll never, ever meet the statutory period of time by tacking. And I've assured on my client's behalf that they have a much better chance of defeating this adverse possession claim. So as a general rule, we don't start threatening about adverse possession till we make sure we got the statutory period of time all locked up through this tacking, and tacking requires privity. So I said there were two ways to do this. One way is a deed. The other way is you can inherit. So if the current owner or possessor inherited the property from, let's say, their parent, under the laws of intestacy, if they're an heir, then they can go ahead and claim privity through intestacy laws. Intestacy means without a will. Or if the will says, I hereby, you know, leave all my property to my daughter, good enough, that's testate. That's good enough. But either intestate laws or the testate, that's another way to have privity. Now, for surveyors, let me say this, that many of the adverse possession situations that we encounter as surveyors, there is privity, because many of these situations, there's an overlap. So to draw a mental picture for you, imagine that there's two deeds out there and there's an overlap in the description between these two deeds. One of the deeds clearly has senior title, right? Whether it's a notice or a race notice or a race state, whatever your state happens to be, one of those deeds has senior title, and therefore the other deed does not have title. They're the junior title and they don't have a good record title to it. However, the junior title is the first one out there to build the fence. Be it they took out, some hardware tape they bought down at the hardware store and measured from some pin and said, okay, here's where my fence goes, and built the fence. They're building that fence along the line of their deed, even though their fence is on land of the neighbors, according to the neighbor's deed, and the neighbor's deed has senior title. We'll see a transfer of that junior deed includes already the possessory claim, because it's sort of, think about it as being built into the deed already. All right, so those are the main elements of adverse possession that have to be proven. And by the way, they have to be proven not by a preponderance of evidence. All right, preponderance of evidence is as it's, I always tend to think of it as Lady Justice with her scales, and you put enough evidence in one side of the scales to just tilt it a little bit in favor. That's preponderance. Preponderance of evidence is what I have to use when I'm arguing about a boundary location, the rules of construction, and so on. But when I am arguing for or against adverse possession, it's got to be generally something like clear and convincing evidence. It can't just be a preponderance. It's got to be clear and convincing. And the possessor has a duty to present all the elements. The record owner doesn't have to do anything. The possessor has to prove each and every one of those elements by clear and convincing evidence. And that's a hard burden to meet. Believe me, it's a very hard burden. I think those of you that even have never dealt with adverse possession can imagine, how do you prove when that building was put up? Oh yeah, you can have the client say, oh yeah, that I remember, that's been here 25 years. Well, prove it. Just getting up on a stand and saying, yeah, it's been there for 25 years is not credible proof. Sure, some old photos, dated photos, that would be great. But how many of us on our own property can produce photos showing buildings being present at a certain date, or fence lines being present at a certain date? Now, sometimes with fence lines, you can go get borings from trees and count the rings of the tree. And yes, that's evidence. All right, but how about a stone wall? Just because it looks old, just because it has moss on it, how do you prove when that wall was built? All right. So clear and convincing evidence is really tough. It's really tough. And again, it's one of those things I say, please, as a surveyor, I know the stone wall looks like it's been there for 100 years. And you can show all the pictures you want in court of this old mossy wall, but that's not credible evidence that it's been there for the statutory period of time. It's credible evidence that it looks like an old wall. That's what the evidence is showing. You're going to need to, get old landowners in there, people familiar with the wall, to say that, they were hunting along it in 1940 and they sat on the wall, or they shot their deer using the wall as a rest. I mean, That's the kind of evidence you need just to prove that it's been there. That doesn't necessarily prove it's open and notorious and continuous and, you know, and these other things. Now, there's some other elements that some states also require. Some states require that you show you pay taxes on the property. Again, if you got an overlap in title, that's pretty easy to do. You pull out the tax receipts, you pull out your description that you've used, and you know, if your tax records show you own 5.1 acres and you actually only own 5 acres, but there's 0.1 acres that was being possessed, and the tax records show 5.1 acres being taxed, okay, you're all set. A lot of states don't require that you prove that taxes were paid, but some do. It's another element. Now, so what mitigates against all this? Well, as a general rule, you can't claim adverse possession against the government. Now, some states allow that. For example, Wisconsin did. You could claim adverse possession against the government, but the statute of limitations was much, much longer. So in Wisconsin, and I forget, I haven't practiced in Wisconsin for some time, but let's say the statute of limitations was 20 years for a claim of possession. But if you're possessing against the government, it was like 40 years you had to show. So some states that do allow adverse possession against the government have much longer statutory periods of time generally. Most states will not allow you to claim adverse possession against the government and against any entity that has the powers of eminent domain. So some states not only include the government, but also include entities that have the power of eminent domain. So what's that mean? It means like the water districts, railroads, any entity that had the power of eminent domain that can seize property, not seize property, but obtain property through eminent domain, also is immune in certain states from adverse possession. Now, here's where I told you, you know, I mentioned the 2 rules that always seem to trump every other rule. Very frustrating. I know it's very cynical view of the law, but I have lots of cases if anybody doubts me about having gotten the cynicism through experience. But there are avenues of law that can be frustrating. For example, let me just throw one out there, and I'm throwing this out there, not that you have to know it as a surveyor, but I want to put let's put it, the fear of the law into, so you never, ever, 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 I don't care what you see, what you gather, you never tell a client, oh, you have that by adverse possession. Or, oh, you've lost that by adverse possession, don't worry about it. I never want you to say that. I would never say that to a client. I don't want you to say it to a client. So let me give you an example that I suspect none of you have ever heard about yet. It applies. Some states are what's called title theory states. All right, let me repeat that term. Title theory states. What's that term mean in the law? That means that whoever holds the mortgage or deed of trust actually has title to the property. Now, I know we all at one time probably told others when they say, oh, you have a beautiful piece of property, say, yeah, the bank actually owns it because we have a mortgage, right? You know, well, that's not too far from the truth. If we lived in a title theory state and the bank has a mortgage on a property, the bank actually has title to the property. The bank, or a deed of trust, I should say, in some states it's a deed of trust. The bank actually has title to the property. Now, if you understand that concept, think about if you have a VA loan, a 30-year VA loan, and you live in a title theory state and you have a building, your client, not you, but the client has maintained a building for 40 years on the neighbor's property, 40 years. And let's assume it's West Virginia, statute of limitation, you only need 10 years. So you're thinking, oh, gee, not a problem. 40 years he's been there and he only needed 10 years. And then I come along as an attorney and say, wait a minute. There was a 30-year VA loan on this property that was just paid off 9 years and 10 months ago. You can't claim adverse possession against the government. So for 30 years, none of that time counts. And so the possessor, even though the building's been there for 40 years, can only claim 9 years and 10 months. Don't you think that's been a shock for people that go into court thinking they've got it all tied up? They got pictures, they got testimony, they got everything. And they didn't have the statute of limitations. Once you remove the fact that for 30 years, the government owned the property and you can't use the claim and time against the government. So VA loans, federal housing loans, state loans, if it's a title theory state, that time does not count in many states. So, again, I just throw that out there to show you how tenuous and how difficult it often is to prove an adverse possession claim. Now, I mentioned when we started this that constructive possession doesn't count. However, let's assume that there's a 10-acre overlap with the neighbor. Your client's deed overlaps 10 acres with the neighbor. And within that 10 acres, your client has built a small structure, let's say a barn. So the footprint of the barn is the actual possession. Let's say the barn, everything, this barn meets all the elements of adverse possession. If the record owner does not have any actual possession within this 10 acres, in many states, the possessor can claim the entire 10 acres. But in order to do that, they have to have actually possessed part of it, and the record owner can't have actually possessed any of it. I just won a case 5 years ago based upon constructive possession, where there's only actual possession of a small portion. My client got adverse possession recognized for a much larger portion than their actual possession of the land. All right, so think of that as an oddity to the element of actual possession. By the way, this is my first time I'm mentoring Mondays, and Trent has said there's a question and answer session right after this. So when 1 hour's up, I'm going to stop. I don't have to be anywhere, but I'm going to stop because I know this is later for some of you than most. but I'll answer any questions. So if you have questions that are coming up, just write them down. All right, just write them down, and I'll do my best to answer them when this 1 hour is up. And those of you that have other plans, fine, you can go off. You've done your 1 hour, and I thank you very much for listening to me for that 1 hour. But I will try to answer that. And if I don't answer it because you had to go off and you had questions, you've got my email now. You can send me the questions by email. All right, let's go on in these handouts. So we've got this, and I've already given you some of the surveyor's role. So what's the surveyor's role in adverse possession? Well, you definitely want to be looking for adverse use, adverse possession that's inconsistent with the record ownership, and locate that. Now, be careful how you show that. Now some states mandatory standards say you have to, but I would caution you about actually putting that on your plat. I would encourage you to put it in a survey report, and then on your plat, say, for important and relevant information, see survey report. The reason is because some states, and I remember Wisconsin, all surveys had to be filed with the county surveyor's office, and you don't necessarily want to, I guess the term is, hang out your client's dirty laundry in public. And so sometimes these possession claims, you don't necessarily need to have the public looking at that. It might jeopardize your client's chances of conveying their property. But on the other hand, you don't want to hide it either. So put it in the report, and on your plat, say, for important and relevant information, see survey report. You can even say, do not use this plat unless you see the survey report. Well, if the plat's got to be recorded, fine, go ahead and record the plat or plan. But certainly the survey report's right there to show that you communicated that information to your client. And then when anybody else needs it, you have it in writing. Just remember, there's some ethical requirements about giving your information that you might have obtained for your client that's harmful to your client to third parties. So I just mentioned that because some states do have ethical rules against that. So you want to map and describe the adverse possession area. And I think I've given you several reasons why you want to include a meets and bounds of this. Then you want to communicate the potential adverse possession to the client. I will do a mea culpa and tell you the first survey I ever did after I was licensed. I was first licensed back in 1978. I know that was like 2 generations ago, before some of you were born, but the very first survey I did, I gave it to the client, and the neighbor's fence was over on the client's property by 2 feet. And I showed the fence, just like I said. Here's the neighbor's fence. Here's your boundary according to deed. And the client immediately went out and ripped out the neighbor's fence. Hey, your fence is on my property, and tore it out. Nothing resulted from that. Maybe some hard feelings between the 2 neighbors. But if that neighbor had perfected their claim of adverse possession, they have damages against my client, and my client could very well sue me. So whenever you see that, you better put it in writing and tell that client, don't be ripping out the fence until you've sought some legal advice here. I know your deed says this, and the neighbor's fence is beyond their deed, but they may have a claim, a rightful title claim to that. So don't be ripping it out. Now, we've all had clients that won't listen to us and go and do it, but that's fine, as long as you got it in writing that you told your client. And explain the ramifications of adverse possession. You just can't show a fence line. You have to actually give the ramifications. I like to think of it as a CYA note, right? And I'm not going to tell you what the letters mean. I suspect somebody will, but I promised. there was the conversation before about, being married for 40 years and, till death. Well, I've had that experience where my first wife died, and it's just like the person said, it's, I didn't want it, but it happened. I got out of the plans, but I got married again, and I'm very happily married, but I don't even come close now to some of you that were saying, what, 40 or 20 years or whatever. But anyway, the reason I'm going down that road is I promised my wife I wouldn't swear. All right. So, CYA, that's all I'm saying. And a good CYA note means that you would show the fence. So you show factual information. That's the out of 3 elements to a good CYA note. One element is you very clearly communicate the facts. The second element that's very critical for you to avoid liability is you must communicate the ramifications of the facts. If you don't do that, you may be subject to liability. It would be like a doctor telling a patient that their blood pressure, all right, is 180/100. Now, some of you, especially you younger people, think, oh, okay, 180/100, But if you're old like me and you've learned what blood pressure should be, that's a dangerous blood pressure. So if all the doctor said is your blood pressure is, 180/100, a patient might say, okay, yeah, that's fine. Thanks, doc. Checkups over this year and go home. And then, dig into the bacon and the eggs and, the other high cholesterol thing. No, that what the doctor has to do then is give the ramifications with the fact. The doctor has to say, your blood pressure is higher than normal. Therefore, you have an increased risk of stroke, heart attack, and other health conditions. So just showing a fence is not enough. You have to say, because this fence is not on the record boundary, there's an increased risk of an adverse claim that ripens into title by the possessor. That's the ramifications that you have to say. Now, I said there were 3 elements to a CYA note, right? Well, the third element you don't have to necessarily do. The first 2, you definitely got to do if you want to avoid liability. The third one, you don't. But the third element is then to advise the client on the facts and ramifications. Now, for the doctor might say, you need to cut out the cholesterol, you need to exercise more, and so on. You got to, for you as a surveyor, sometimes for something like this, you simply say, make sure you see an attorney. Right? Go see an attorney. That's your advice. So that's the 3 elements you always want to think. So when you put CYA notes on a plan, are you covering those 3 areas? Are you covering those 3 areas? And actually the first 2 areas, I'm not concerned with the third one. You're not going to get liability for that, but the first 2 you definitely want to cover. So if you only got 1, you're still subject to liability. All right. Question I often get: if the surveyor marks the boundary, will the marked boundary stop adverse possession? Well, a lot of times you get from an attorney, well, I don't know, it depends. I'm going to just tell you, no, has absolutely no. So the client say, well, mark my boundary, I don't want adverse possession claim. It won't help a bit. They have to actually remove the possession. If they want to stop the adverse possession claim, just sending the surveyor out there with a can of marketable paint and so lots of ribbon is not going to do it. All right. If the possession has been maintained for decades, and the surveyor is the absolute opinion, I already answered this, right? Can the surveyor show title to the possession boundary? And the answer is definite no. That title, I don't care if they got adverse possession, is not marketable title. And I don't have time to explain the vagrancies of different types of title, but it's not marketable title. There's only 2 ways that possession, title by possession, can ripen into marketable title. The one way is you go to court and you get a verdict in favor of the possession. Now you got marketable title. The second way is to go to the record owner and get a deed from the record owner for that. And you say, well, why would they do that? Well, believe me, I've, in arbitration I've managed to get that. Or negotiation. It sometimes happens. The record owner just doesn't want to fight it. And for something else, maybe some money, they're willing to sign over a deed. So now that possessor has marketable title. They not only have title by adverse possession, but it's marketable title. And that's important. Is adverse possession limited to the area of possession? And I said, yeah, generally, but sometimes you can get title by adverse possession to the entire area described within the deed. Now I have a case here and you can read it because we don't have only a couple minutes left, but let me just summarize it up. Wisconsin case, a surveyor went out there actually doing a mortgage loan inspection, saw these old fences, drew it up. The buyer bought the property based on the fact that it looked like whatever was in their deed they got. Years later, a surveyor came out and located and I should say the fences matched up with county surveyor monuments. So it looked good. Years later, road construction, and they uncovered the original government section corner. No question about the original government section corner, and the county surveyor's 1910 monument was not correct. There's absolutely no question about it. The neighbor who the surveyor was working for, that when the roads crew picked up the original monument, showed that the garage was over the boundary. Now, this is the garage of the owner of the person that got the mortgage loan survey. He did two things. Well, first thing he did is he claimed up to the fence by adverse possession, and the court awarded him title by adverse possession. It cost him $50,000 or thereabouts in order for him to litigate the adverse possession claim. Once the judge said, okay, you got adverse possession, he then turned around and sued the surveyor. Now think about this. What the surveyor showed on his plan as what that client's boundary was, the court said, yes, that's your boundaries. But the court, when it finally went all the way up to the Wisconsin Supreme Court, the Wisconsin Supreme Court said, surveyor, your duty was not to show where the person owned. Your duty was to show where the person's deed locates their boundary. And therefore, you do owe it to your client for the litigation costs in order for them to prove where they own to, not where their boundaries were, but where they own to. And so, please, your job as a surveyor is to locate where the record boundaries are, not where the ownership boundaries are. Right? And again, that might seem a little deep, and it probably is to some of you just starting, but there is a difference between record boundaries, possession boundaries, and ownership boundaries. All right, time's up. Turn this over to Trent, and any questions?
Good stuff. That was good, Knud. Yeah, there's a few things floating in the chat. Does anybody want to kind of unmute themselves and ask a specific question? Jason has one. So does title theory base the lien against the property title to be the higher in possession versus the deed holder under that discussion? I thought the deed as a physical thing is just that, and title incarnation, and the bank is holding the lien to that. Jason, you can unmute yourself if you want, kind of go into that.
Sorry, yeah, no, that made it confusing, because if you've got the deed, that's the physical representation of title. the bank doesn't own the title. They just have a lien against your title. So does the bank actually have title in front of you because they have a lien, or do you actually have it? And if you forfeit it because you default, they get to perfect it. That was my question, essentially.
Got it.
It all depends. Not all states are title theory states, but in title theory states, the person with the lien has the title, and the person with the deed has what's known as equitable title. Right? They have what's called equitable title. What equitable title means is that that if the person satisfies the terms of the lien, the lienor must remove the lien. Must remove the lien. All right. So under a title theory state, the person with the deed actually has what's called equitable title, but the lien has the actual title to the property. And see, this
Okay.
is this is deep in the law. And again, I'm not expecting any surveyor. In fact, most attorneys don't know this. But this is the finer points of the law that sometimes adverse possession hinges on. Go ahead.
And I was just going to say, I think that for me, I'm no attorney and I don't want to be, but that's why when I sold my house, when I purchased my house, I really didn't listen a lot to the realtor because they weren't an attorney as well. And I felt like their advice is basically just like a used car salesperson. So when I sold my house, I sold with a special warranty deed because prior to me owning the house, lots of interesting things had happened. And I wasn't taking any responsibility because I had no idea what someone had done before I took possession. So I sold it under a special warranty deed and no one complained about it because they wanted the house because property was just exploding. They wanted it so bad they didn't care. But for me, I was like, hey, I can tell you from when I bought it to when I sold it, and that's it. That's all I'm taking responsibility for. Have a nice day.
That's good. And in truth, a lot of people think if I ask the typical buyer out there, do you want a general warranty or would you like a special warranty deed? And the typical buyer out there said, well, I'll take the special warranty, not realizing that the general warranty was a much better warranty than a special warranty. But anyway, that's getting a little deep there. So go ahead. Next question, or Jason, if you have some more, that's fine.
Yeah, no, Adam had one in here. Have you come across any instances where municipal zoning ordinances can interfere with an adverse claim? Here in Elliott, we have an ordinance where you must build your fence 2 feet onto your property. Ah, that's a good one.
Interesting.
Problematic.
For sure.
I served on our municipal zoning board of appeals, and I often had to correct and look at our zoning ordinance and say, you do not have, your ordinance is written by somebody that doesn't know the law. I'll give you one example. They said that the building setback, front setback has to be 30 feet from the property line. And the code enforcement officer thought it was the right-of-way line. I said, no. I said, that's not true. And I had a lawyer come before the zoning board of appeals and correctly argue that the front property line was the center of the road. And the code enforcement officer says 30 feet from the center. Well, that means they can be 5 feet from the edge of the road. And I said, I'm sorry, your zoning laws are not written with a view to the law. And I can produce, 80 cases in this state that clearly say the center of the road is the property line. If you want to measure from the road right away, then that's how the zoning should have been written. And the person got to put their building within 5 feet of the edge of the road, and then they quick rush through a change in the zoning. But I mentioned that just because it's often the case that the local municipality is just not aware of the law. And it's very true that the neighbor then, if they start mowing and planting their garden and putting improvements up to that fence line, may steal that 2 feet away.
Yeah, no kidding. That's crazy. That is a good one. One more, and then I'll jump to George. But Jen had a question: what happens in an overlap if both parties possess part of the overlap?
If both parties possess, so the record title owner possesses part of the overlap, and the possessor, the junior title, overlaps, then the junior title can only make claim for adverse possession to what is the actual possession.
Got it. Perfect. Go for it, George.
Okay, so am I muted again?
Nope, you're good.
Okay, so in your example of the guy that built the barn on the 10-acre,
We lost it.
Yeah, George.
George froze. While we wait for George to come back, Jen says, would the junior party also get an easement to access their barn or whatever the case may be?
No, not unless they've used that to do it. I mean, I'm assuming maybe it's just part of the barn is over on the neighbor's land. So yeah, they can go within their barn and use the entire inside of their barn. But sometimes it's hard to go out and actually paint your barn because the judge has been very strict about, let's say, going with the actual building, and maybe not even what we call surveyors, the drip line. And so it's very important sometimes when I'm litigating an adverse possession claim to tell the surveyor, don't just get where the walls are, get where the drip line is. And if there's evidence that the person has been, tramping around the edge of their barn, I don't know, to paint or something like that, also show that so we can claim that as part of this actual possession.
Gotcha. Perfect. All right, George is back.
okay, so I don't know if you heard my question or not, or if you answered it. Okay, let me try again. Yep. The barn on the 10-acre piece.
George has to turn off his video.
Yeah, there you go. Yeah, we could try that.
Yeah, that's probably true. I've seen that happen. In fact, I have my video turned off just to reduce the bandwidth.
Yeah.
Because if you're on a iffy Wi-Fi, that'll mess it up. So George, you might have to turn off your video and just keep your just talk to us.
Right. We'll wait for him to come back. Anybody else want to chime in while we wait for George? Anybody have any more questions? Some good stuff tonight. And while we do wait for George,
there's one from Jen.
Another one from Jen. Okay. So if the whole barn is in the overlap and there's a well-worn way to the barn, they might get fee to the footprint or drip line.
And the way.
In the way.
Yep. Again, we go back to what the judge, I see judges trying to split the baby all the time. And, it's like, okay, I'll give you a fee simple title to the barn, but you only get an easement 5 feet wide to walk to the barn, or if it's, you're bringing a tractor in, what's the width of your tractor? That's all you're going to get, that width. So heaven forbid you get a bigger, wider tractor because you're not going to be able to use that.
Gotcha. Perfect. I think we lost George, but he usually jumps back on when he comes on.
Yeah, I see the chat. Can I know if we make an adverse claim, i.e. mow a little more each year with the intent to make an adverse claim? Trouble is when you keep adding to it. So if you add an extra, if you started out with a foot and then next year you add 1 foot, you see, you can maybe make the statutory limitations is going to be a rolling statute of limitations before you can claim it all. Right? Because if you only claim that foot, that 1 foot, And so you have to wait, let's say 10 years under the statute of limitations. And so if you've added another foot next year, you're only at 9 years for that extra foot. And then it's hard. How do you prove that? You really need to set up a proof that, you know, you have this 1 year rolling. I mean, proving adverse possession is difficult. And remember, it's up to the possessor. Once the possessor is made and able to prove all the elements, then the record owner is going to have to prove that there was permission, if there was. That's the only thing that the record owner needs to come forward and prove, but only after the adverse possessor has made proven all the other elements.
He was saying, how about putting up a fence and basically just starting the clock? So put up a fence, start mowing the lawn. Yeah, I guess, and hostily take over, right? I guess at that point.
Well, okay.
I don't think the intention was to give instructions to our attendees on how to adverse possess. So, all y'all, don't be adverse possessing against your neighbors. It's not.
There you go. Good disclaimer. Good disclaimer. Sean has a good one. What's a good example of how a possible adverse possession is shown on a map?
I would show where the record boundary is according to deed, and then show possession. There's nothing wrong with saying potential adverse possession. Just don't be certain, because you don't know if it was permission maybe given 20 years ago to put up the fence. You can say something like possession not conforming to the deed, or use not conforming to the deed, or something like that, which would be true even if the person got permission to put that up 20 years ago, which means it's not hostile and it would never be adverse possession. Still, the possession doesn't conform with the deed. So I guess you know, be more like a lawyer and a little wishy-washy with your statement.
That's awesome. There's a good disclaimer. That's good. George has not jumped back in, so I'm not. Maybe he's rebooting. There's a good one in the chat. If you can read that one from Ray or from Jay.
Oh yeah, Jay Ray, a good friend of mine, or at least I hope I'm a good friend of his. Regarding the right of way to the barn, I think the courts often fail to acknowledge issues related to the claim of ownership. They probably do. Spickler versus Ginn at Maine fails to acknowledge use of a right of way along the coast with deep water frontage, which would normally be adequate access over here. The only address the specific issue addresses in the case. Jay is being very specific, but I, as an attorney, can be incredibly frustrated with judges. We tend to maybe put judges on a pedestal, but a lot of judges maybe had, 40 years of family law before they were appointed to a bench, or maybe they were criminal lawyers, or maybe prosecuting attorneys, and they've never dealt with real estate. And all of a sudden they're on given a judge, and you're throwing a bearing at them. They have no idea what a bearing is. I'll just give a real brief. About 10 years ago, I went to a pretrial conference as an attorney in a boundary dispute case, and went back into the court. It's a very competent judge. She's still on the bench. And, pretrial meeting, you don't have your clients there. It's just the attorneys. And the judge was very frank with us and said, listen, she says, I've never dealt with real estate. I'm not even going to claim I'm going to understand what you all are talking about. I would really like it if you'd go out there and settle this claim before you come to my court. She says, I will try my best to understand it. But she says, I was never good with math, and real property law was just barely passed at law school. I don't have much hope for me understanding what you all are going to be talking about. There we go. That conversation has occurred dozens of times in my professional career. And as a surveyor, we tend to think, oh, the judge is going to understand what I'm saying. No. You start talking about traverse, GPS, rules of construction. The judge is like, probably, no. Probably doesn't understand. Yeah, so a note here, like hiring a good land surveyor, it's equally important to hire a competent land use attorney. It certainly is. Yeah, judges make mistakes. A lot of my work in the past has been when two land use attorneys realize that if they go to court, they're dealing with a judge that doesn't understand property law and will decide to arbitrate the case and appoint me as an arbitrator. Now we're cooking. I'm not saying I'm a perfect judge or anything. I'm not making that claim. It's just that when a surveyor gets up and starts talking about traverse points and fence lines and ring counts, I understand it. They don't have to get and start defining what GPS is and what the probable errors are and all that. The testimony just flows right on. So sometimes it's better to get both sides to use a special master or to arbitrate. All right, who else we got? Oh,
yeah, Brian just put a good one in the chat about a case going on in Maine. Yeah.
Oh,
a little extreme. Yeah.
I have a picture of that. I was involved a little bit right at the beginning. Quick rundown. A surveyor went out, used the deeds, didn't look at the rules of construction, in my opinion, put a pin in, the neighbors were in dispute. The one person was at work, the other one brought in got one of those big chop saws that go through everything, rented one, cut the garage right in half, brought in a excavator and removed the half of the garage, put it in the person's driveway. So when they came home, they only had half a garage and it was in the driveway. And the garage had been there for, I don't know, 30 some years. So I think the surveyor is really in a very bad situation. I think the client can sue him. I think to not tell your client about adverse possession and like I say, do it in writing was bad. The other bad part is that the deed said thence along the garage, edge of the garage. So it was a monument that surveyor just ignored, just went strictly with distances. And so I think the surveyor is facing some real liability in that case, but it is the picture says it all. If you've ever seen that picture.
Yeah, I do remember seeing the picture, but oh my goodness. Yeah, vents along the garage. Oh boy.
Yeah.
That's scary. Thanks for bringing that one up, Brian. Anybody else got anything else? I don't think George is going to jump back on us with us tonight. So
I see I have a few students and ex-students that are
you sure do. You sure do. Yeah. Well, if nobody's got anything,
I threw one in there, Trent.
Yeah, exactly. Yeah, give us updates on the garage. Yeah, we'll have to see how that one goes for sure. Knud's back next month as well for us, so we appreciate that. And if nobody has anything else, we'll let Knud leave the parking lot.
All right. Thank you all. And Trent, thanks. This is a great service.
Yeah. Thank you, sir.
Yep. All right. Bye now.
Awesome. All right. Have a good night, everybody. Bye, guys.
Bye-bye.
Have a good night.
Bye.